Good afternoon, and today we're talking about safety rule violations, and the reason we're talking about it is because I actually had a hearing earlier last week on Friday, which is kind of why I didn't post on Friday, about what happens on safety rule violations. So, bottom line, first thing is, in general, injured workers get their benefits regardless of who's at fault. And so that's why we kind of say it's a no-fault system, meaning that it doesn't matter if your injury occurred because of your negligence or the employer's negligence or somebody else's negligence, just doesn't matter one little bit. Your benefits are still the same. And what that means is, to some degree, sometimes workers' compensation can be a lot less drama because we don't have the situation where we're trying to put the fault on the employer and then the employer is coming in saying, well, but they were also negligent, etc. We don't have that. We don't have any of that in Colorado. It's a no-fault system. Nonetheless, there are certain things that an employer can allege which will lead to a reduction in benefits, and it's 50% reduction in monetary benefits. So, it doesn't mean the medicals are cut, it just means monetary benefits are cut, and those can be 50% if the employer can show that you have violated a safety rule, okay? Except it's a little more complicated than that, and we're going to go over that. But one of the things that you need to know, if you're an injured worker and you've sustained an injury on the job, the insurance company is now paying you even less, and they're saying, hey, you violated a safety rule violation. You really, really, really need to come and talk with us because we handle these all the time. And one of the things that you need to know, one of the bad things is the insurance company can just start paying you 50% of your benefits without having to prove that you violated a safety rule. And so they put the ball in your court, so to speak, and you have to take them to hearing and you have to make them prove it. So a few things you need to know about safety rule violations. Number one is it's their burden of proof. They have to prove it. So even if they take it and if they claim it, you can take them to hearing and you can make them prove it, okay? Now, when we're talking about safety rule violation, typically we're talking about either the employer had some sort of rule like, don't put your hands in a machine, or wear your hard hat, or wear special, safety boots, or something. And think about an employee says, you know what, I don't care, I think it's a stupid rule, I'm going to break it anyway, and then gets injured because of it. That's what this rule and law was designed to cover. It is not designed to cover like forgetfulness or oops or it was an accident or didn't know, any of that. So it's a very serious allegation. It's a very serious reduction in benefits because essentially it puts the worker down to 1/3 of their pay if they're off work. So employers have to show 5 things. Okay, it's not just enough to show that to the employee broke the safety rule. They've got to show 5 things. So number 1, the employer has to show that they adopted the rule. It's not enough for them to say, oh, we had this rule. We always tell our employees to do it. They've got to show they actually adopted the rule. Okay. Number 2, they have to show that they communicated the rule to the employee. Okay. It's rarely good enough for employers to go, oh, we tell them when we get hired. I mean, I've had clients who were facing a safety rule violation. The employer says, well, here's the handbook, and we told him to sign it, and we told him to sign that he received it, and it's 300 pages, and there are about 45 different safety rules all sprinkled around there. That's not communicated, okay? It's not enough. Now, it's helpful, and it may be a start, but it's not enough, okay? So, number 1, it has to be adopted. Number 2, it has to be communicated. And number 3, it's got to be enforced. And here's where employers really kind of mess up in terms of showing that there's a safety rule, that it was violated, and that they can cut the compensation of injured workers by 50%. Enforced means that when the employer was aware of people violating that rule, they would write them up. They would fire them, they'd tell them to go home, they would do something. And we're talking about steps that the employer took before the injury occurred to show that they were actually enforcing the rule. I mean, often one of the things that we look at when one of our clients comes in and they've been accused of violating a safety rule, I'm looking for write-ups. I'm looking for, even after the injury, hey, we're writing you up. Because if they don't do that, that's excellent proof that they really aren't enforcing the rule. And so, again, it's not just enough that they adopted the policy, that they communicated the policy. Number 3 is they've got to enforce it. Number 4, they've got to show that the injured worker willfully violated that safety rule. It can't be because of negligence, forgetfulness, inadvertence. Sometimes employees have said, well, something was happening. My supervisor said, quickly go do that. I ran and did it, etc. Those things typically are not going to be considered willful, okay? Now, again, employers have a hard time proving willful because sometimes how do you prove what's in the heart of people? But it's still enough to prove that if it's willful, if the employer can show all of those things adopted, communicated, enforced, and then say there was no other reason for this employee to be doing this other than just a screw you, I'm going to do it my way, etc. Okay, and then there's 5th thing. So to repeat, which is what we lawyers do a lot: adopted, communicated, enforced, a willful violation. And number 5 is that the violation led to the injury. One of the more kind of gruesome cases I had where there was a safety rule violation was a trucker who died in a motor vehicle accident in his truck, and we actually had to hire accident reconstruction specialist because the insurance company was saying that the employer had a rule of you must always wear your safety belt, and this guy maybe was not. So one of our defenses to this was he was wearing the safety belt and you can't prove that he wasn't. And number 2, one of the things was the accident was bad enough that we actually had people who said he would have died anyway. It was a death claim. He would have died anyway, even with the seatbelt. And so not wearing the seatbelt didn't change the outcome, didn't make him more injured or less injured. And that's important to know because one of the hard things for these safety rule violation cases is it's not just the injured worker who's subject to them, it's also the injured worker's beneficiaries, the spouse and the children who can have their benefits cut if their loved one died in an on-the-job injury due to a safety rule violation. So, bottom line is, one of the big things that can happen that can reduce compensation in Colorado, notwithstanding the fact that it's a no-fault system, is if an injured worker gets injured because he or she willfully violated a safety rule violation. If that is happening to you, if you are getting your benefits cut, if you know someone who's getting their benefits cut, they need to come see an attorney. And as always, we offer free consultations. And so if you or anyone you know has been injured on the job in Colorado, please refer them to us. We are happy to talk with them. We offer free consultations. We've been helping injured workers in Colorado since 1997, and we'd love to earn your trust and confidence as well. Have a great day. Thank you.